Okay, shall we start? Good afternoon, everyone. Thank you for joining us today for another Manila House webinar. Today, we're talking about the anti-terror law and the freedom of expression and how it's impacted with attorney Jose Manuel Diokno, also known more popularly as Chel Diokno. On behalf of Manila House, I'm Bambina Olivares, and I'm the Director of Programming and Public Relations for the club. I'd like to welcome all our members who have joined us today. We have quite a big crowd, and we are also live on YouTube for the overflow. I hope that you can join us there for those that can't get in. Before I turn you over to Attorney Chel, let me just give you a brief introduction. Some of you might know him from the elections last year. He ran with the Liberal Party. He was one of the Magic 8 slate. Attorney Chel Diokno is also the founding dean of the Salle University College of Law and chair of the Free Legal Assistance Group known as FLAG. He has been practicing law for 30 years and gained prominence as a human rights lawyer and litigator. In 2012, he was shortlisted by the Judicial and Bar Council for the position of Associate Justice of the Supreme Court of the Philippines, with which he would also later work in various capacities in several committees and technical working groups. Though already established in legal and human rights circles, Dean Diokno gained a wider public prominence when he ran for the Senate seat on a platform of justice and judicial reform during the 2019 midterm elections. He emerged as one of the leading opposition senatorial candidates, largely due to an outpouring of support from young voters who dubbed him as their woke lolo because of his progressive views and his advocacy for empowering the youth. The DSLU College of Law, which opened in 2010, is the first law school in the Philippines to highlight human rights and legal aid as part of its educational program. The Free Legal Assistance Group, or FLAG, is the oldest organization of human rights lawyers in the Philippines. Established in 1974, FLAG is known for handling cases involving civil, political, economic, social, and cultural rights. FLAG also spearheaded the campaign to abolish the death penalty, which succeeded in 2006 when Congress enacted Republic Act 9346, prohibiting the imposition of the death penalty. Dean Diokno has conducted training courses and written training manuals for government agencies and other lawyers' groups. He has also trained journalists, law enforcers, human rights defenders, church workers, and the urban poor. As a training expert, he has worked with the European Union and Philippines Justice Support Program, the International Labor Organization, the American Bar Association in the Philippines, the Millennium Challenge Account in the Philippines, the British Embassy, and the Asia Foundation, among others. After his campaign in 2019, Dean Diokno has also become a highly sought-after keynote speaker for various events with numerous schools and organizations all over the country, which serve as a venue for continuing his advocacy for justice, human rights, and empowering the youth, as well as for continuing his engagement with young Filipinos. So today we talk about the anti-terror law, which Dean Diokno has voiced his reservations about, and he's here to talk more about it. And so without further ado, just to let you know, if you have any questions, please put them in the Q&A box. So Dean Diokno will have a short presentation. He'll speak about the law in general, and I'm sure you all have a lot of questions. So we'll have time. Hopefully we'll have time to go through all your questions. Okay, thank you so much, Attorney Chel, for joining us today. We're very honored to have you. Thank you. Just let me know when you need to use the screen.
Sure. Thank you, and good day to everyone. I'd like to thank Manila House for this opportunity to talk about an issue that's really hot topic these days, and something that I think everyone should know about. When it comes to the law, it seems to be an exclusive field that only lawyers can understand. But it shouldn't be that way. Every single citizen must be able to understand what our laws are, because the laws are intended for all of us and not just for lawyers. So one of my purposes this afternoon is to simplify what might be an abstract or a complicated law and hopefully make it understandable to everyone. I've prepared a couple of slides, not much, just to help you see what the law is all about. And perhaps we can share screen now.
Yeah. You can use it already. Should
Yeah.
be okay.
All right.
There you go.
There we go. Well, the Anti-Terrorism Act of 2020, as you know, was just passed very recently. It took effect on July 22, just a couple of weeks ago. And what should I know about it? Well, a couple of things. First, it contains a new definition of terrorism. It has 7 new crimes. There are new powers given to the Anti-Terror Council. Many of the safeguards that were in the previous law, the Human Security Act, have been removed. And there are what I consider to be either questionable or dangerous provisions contained in this new law. We had a terror law already since 2007 that was known as the Human Security Act. And I think you will understand the new law better if we compare it with what you see in the old law, or what we call the Human Security Act. To the left of the screen is the definition of terrorism under the Human Security Act, and to the right is the definition under the new law. You will notice that if you look at the left of the screen, there are really 3 components to the crime of terrorism under the HSA. One is the commission of what they call a predicate crime. So if a person commits piracy or mutiny, rebellion, the crime of coup d'etat, murder, and the other crimes that you see on the screen, and for the purpose or thereby sowing and creating a condition of widespread and extraordinary fear and panic among the populace, that's the second component, in order to coerce the government to give in to an unlawful demand. That's the third component. That is the crime of terrorism under the old law. It's quite simple. You have a predicate crime, and then the purpose is to sow fear in the populace in order to coerce the government to give in to an unlawful demand. So, for example, if there were a suicide bomber who would announce to the government, if you don't release my colleague, I will explode this weapon of mass destruction, definitely that would fall under the act of terrorism under the Human Security Act. How about the new law? Well, the new law dispensed entirely with that old definition and replaced it with a much, much broader definition. It says terrorism, and now I'll direct your attention to the right of the screen. Terrorism is committed by any person who, within or outside the Philippines, regardless of the stage of execution, does any of the following. First, engages in acts intended to cause death, serious bodily harm, or to endanger a person's life, or to cause extensive damage or destruction to public or private property, or to cause extensive interference with or damage or destruction to critical infrastructure. So that's the first part of the law. Second, any person who develops, manufactures, possesses, acquires, etc., weapons, explosives, or biological, nuclear, radiological, or chemical weapons. And third, any person who releases dangerous substances or causes fire, floods, or explosions for the purpose of, according to its nature and context, 1, to intimidate the general public. Second, to create an atmosphere or spread a message of fear. Third, to provoke or influence by intimidation the government or any international organization. Fourth, to seriously destabilize or destroy the fundamental political, economic, or social structures of the country. Fifth, to create a public emergency. Or sixth, to seriously undermine public safety. So you will notice if you look at the top portion of both sides of the screen, the one in black, that the previous requirement of predicate crimes has been replaced by either of 3 acts: having, developing, using, etc., explosives, weapons, releasing dangerous substances, or engaging in acts intended to cause death or damage to property or critical infrastructure. You will also notice at the bottom of the slide, if you look at the part in red, that under the old law, all you needed was to show that widespread and extraordinary fear to coerce the government to give in to unlawful demand, when the new law now has more intimidating the public, creating fear, and so forth. There's also an additional clause in the new definition of terrorism that some say is a saving clause. It says, provided that terrorism shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. I would have been very happy with this additional clause if it ended after the word civil and political rights. Kung sana may period na doon, that would have been perfectly satisfactory. The problem with this saving clause is that it's not really a saving clause, because what it really means is that even if you are exercising your civil and political rights, if in the eyes of the government your intent is to cause death or serious physical harm, or to endanger a person's life, or to create a serious risk to public safety, that would still qualify as terrorism. So for example, if a person, a civic leader, were to make a call for people to assemble at EDSA, similar to the call made by Archbishop Cardinal Sin way back in 1986, that would probably qualify here, because by calling people to gather together under the time of COVID in a pandemic, that would probably be creating a serious risk to public safety and endangering persons' lives. I'll go back to that point later. So what's different about the new definition of terrorism? Well, I already mentioned this. There's no more requirement of predicate crimes. No actual death, extensive damage, destruction, or interference is required. Let's go back and let me show that to you. If you look where the arrow is, it simply requires that the person engages in acts intended to cause death, etc. It does not require that actual death, actual injury, actual destruction to property or to critical infrastructure occurs. It simply requires that you did an act that was intended for that purpose. The next difference between the new definition of terrorism and the old one is that the earlier phrase, thereby sowing and creating widespread and extraordinary fear and panic among the populace, has been replaced with creating an atmosphere or spreading a message of fear, which is a much broader element. The next difference is that the earlier requirement of, in order to coerce the government to give in to an unlawful demand, has been removed entirely in the new law, and that there have been additional purposes put in to intimidate the general public, provoke or influence by intimidation the government, seriously destabilize or destroy political, economic, or social structures of the country, create a public emergency, or seriously undermine public safety. You might be wondering, what does critical infrastructure mean? And I think this is a very important point, because this would, many cases would probably revolve around this. The law itself defines critical infrastructure as an asset or system, whether physical or virtual, so essential to the maintenance of vital societal functions or to the delivery of essential public services that the incapacity or destruction of such systems and assets would have a debilitating impact on national defense and security, national economy, public health or safety, administration of justice, and other functions analogous thereto. It also provides, the law provides, that this may include, but isn't limited to, an asset or system affecting telecommunications, water and energy supply, emergency services, food security, fuel supply, banking and finance, transportation, radio and television, information systems and technology, and chemical and nuclear sectors. So if going back to the example I gave earlier, if let's say a similar situation occurs, let's go back to 1986. If this terror law were in effect when Archbishop Sin made the call for people to gather in EDSA to protect Enrile and Ramos, who had defected from the Marcos regime, that would probably qualify as terrorism or as inciting to terrorism, a crime which is now a new crime that is created by the Anti-Terror Act, which says that anyone who incites any other person to commit the act of terrorism would be guilty of inciting to terrorism. Now, why do I say that that would qualify? Well, if we go back to the definition of terrorism under the new law, it says anyone who engages in acts intended to cause death, etc., or to interfere extensively with critical infrastructure. And if you recall, when Archbishop Sin made that call, thousands of people gathered in EDSA, pretty much brought the entire Metro Manila to a standstill. Delivery of public services was halted, at least temporarily. There were, we could say that there was extensive interference with critical infrastructure, because critical infrastructure is defined quite broadly to include any kind of delivery of essential public services, administration of justice, national defense and security, and so forth. And the purpose would fall within one of the law's purposes, which would be either to intimidate the public or to create fear, or to provoke or influence by intimidation the government, or to seriously destabilize or destroy the fundamental political, economic, or social structures of the country. On the other hand, if we fast forward and let's assume that a civic leader or a religious leader today were to make a call for a type of EDSA type of assembly, that would also probably qualify as an act of inciting to terrorism, because by calling on people to gather together en masse, that would be endangering public life, a person's life, because of the risk of COVID infection. If their assembly in EDSA would disrupt the delivery of public services, that would also be interference with critical infrastructure. And the purpose, again, would fall within any of the purposes that you see here in red ink. So that's one of the observations that we can make initially about the definition of terrorism under the new law, and that is it is so broad that it could readily cover acts that we would commonly not associate with terrorism, that we would say would be protected under the Constitution as part of our basic rights. Now, you might be wondering, saan nanggaling ito? Where did this new definition of terrorism come from? Actually, it came from a proposed UN Convention on International Terrorism that was submitted way back in 1996 by India to the United Nations. Up to now, however, that the proposed convention has not been approved, largely because the members of the UN cannot agree on how to define terrorism. As the saying goes, one person's freedom fighters are another's terrorists. And in fact, there are over 100 definitions of terrorism worldwide. However, when I looked at the proposed UN Convention and I compared it with our law, I also noticed that there were substantial differences between the two. If you look at the portion on the left of the screen, especially the top paragraph, it says any person commits an offense if they intentionally cause any of the following: death, etc. In our law, it says it doesn't require that these things really happen. It simply requires that there are acts committed that are intended to cause death, etc. So that our law is much, much broader than even than the proposed UN Convention. The second is that the purposes in the UN Convention are limited to two: to intimidate the population or to compel a government or an international organization to do or to abstain from doing any act. That has been expanded substantially in our law, because we have added to create an atmosphere or spread the message of fear, to provoke or influence by intimidation the government, to seriously destabilize fundamental political, economic, or social structures of the country, create a public emergency, or seriously undermine public safety. Next are the crimes. And here, this is really something that we are concerned with because of the possibility of persecution rather than prosecution. Under the Human Security Act, you only had two crimes: terrorism and conspiracy to commit terrorism. Under the new terror law, we have 9 crimes. We retained terrorism and conspiracy, but now Congress added threat to commit terrorism, proposal to commit terrorism, planning, training, preparing, and facilitating the commission of terrorism, inciting to commit terrorism, recruitment and membership in a terrorist organization, foreign terrorists, and providing material support to terrorists. Most of these crimes are self-explanatory. I'd just like to focus on 3 crimes because I think they are of utmost concern as far as the possibility of these crimes being used for political purposes or to go after perceived critics of the administration. The first is inciting to commit terrorism, which is known in legal parlance as a speech crime, because simply by speaking publicly, one could already be prosecuted, arrested, and punished. What does this law, this crime provide? It says any person who, without taking any direct part in the commission of terrorism, shall incite others to commit any of the acts defined as terrorism by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end. So this really directs the crime towards speech. And that, of course, has a tendency to create a chilling effect on people because now that this law has taken effect, anyone involved in communication, journalists, educators, speakers, etc., would have to think twice before they say what they say because they would have to consider, would my language, might that be considered as inciting to terrorism? Might I be arrested or prosecuted for saying these things? The next crime is planning, training, preparing, and facilitating the commission of terrorism, which basically penalizes people who participate in the planning, training, and so forth of people involved in terrorism. But if you look at the definition of training, it's defined as the giving of instruction or teaching designed to impart a specific skill in relation to terrorism, as opposed to general knowledge. The concern that we have here is that under the new law, an organization could be prescribed or declared a terrorist organization without notice and hearing to that organization. So that if you are, let's say, providing training, let's say you belong to an NGO or to a business or to a people's organization that provides training to other organizations, and you don't know that this particular organization that you're giving training to has been proscribed by the Court of Appeals because there's no requirement of publication or notice and hearing. If it's a preliminary order of prescription, you might later be charged of providing training, etc., or to the commission of terrorism under this particular crime. The third is the crime of providing material support to terrorists, which simply says that anyone who provides material support to any terrorist individual or organization could be punished under this law. But again, material support is defined quite broadly. It's defined as any property or service, including financial securities, financial services, lodging, training, expert advice or assistance, safe house, communications equipment, facilities, and transportation. So again, the reach of this particular provision is quite broad. Next, and I'm almost done with my slides, is what safeguards have been removed or modified by the new law. The Human Security Act had a whole bunch of safeguards that were put in place because the legislators then knew that terrorism is a very serious crime, and even just being branded a terrorist could destroy a person's reputation. So they put in, for example, a provision in the Human Security Act that it could not be used 1 month before and 2 months after elections. And of course, this was designed to avoid its being used for political purposes. Unfortunately, that safeguard has been removed in the Anti-Terror Act. Second, the Human Security Act required that any time a person is arrested under the terrorism law, the arresting officer must immediately bring that person to the nearest judge. And the purpose is to ensure that no kind of torture was put against that particular person. Unfortunately, again, that safeguard was removed. It's not found in the Anti-Terror Act. The third safeguard was the requirement in the old law that if you are arrested without warrant, you can only be detained for a maximum of 3 days without any charges being filed against you in court. In the new law, however, that has been modified, and now that is a period of up to 24 days that you could be detained after being arrested without warrant, without any judicial charges being filed against you. The next safeguard is with regard to surveillance. Under the old law, the only time surveillance of suspected terrorists could be authorized by the court is if there are no other effective and readily available means to secure the evidence sought. That requirement is no longer found in the new law, and therefore surveillance may be authorized even if there are no other effective and readily available means to secure the evidence sought. There are around 5 other safeguards that have been either removed or modified by the new terror law. Under Section 18 of the Human Security Act, the only time that the suspected terrorist could be arrested without warrant would be as a result of judicially authorized surveillance and examination of bank deposits. That, unfortunately, has also been removed under the new law. The next safeguard is about proscribing of a terrorist organization. Under the old law, an organization could not be declared a terrorist organization without notice and hearing. Under the new law, the Court of Appeals can issue a preliminary order of prescription without notice and hearing, and solely on the basis of the submissions of the Anti-Terror Council to the Court of Appeals. The next is a broadening of powers. Under the Human Security Act, only civilian law enforcement personnel had the power to arrest and detain. Under Section 29 of the new law, the military was also empowered to do so. The next is that under the Human Security Act, only the courts had the power to declare organizations as terrorist organizations. Under the new law, the Anti-Terror Council has been given that power to designate individuals or groups as terrorists, even if we all know that the ATC is not a court, it's not clothed with judicial power, and its members are all members of the executive department that answer directly to the president. And finally, the last safeguard that was removed was the creation of a grievance committee under the old law, expressly for the purpose of receiving and evaluating complaints against police and law enforcement officials in implementing the law. That, again, has been removed. So I'm down to my last slide, and which is now directed to the question, what are the law's questionable or dangerous provisions? Well, number one, and I've discussed this already, it's inciting to terrorism. Number two, providing material support. Number three, planning, training, preparing, and facilitating the commission of terrorism. 3 of the new crimes provided in the Anti-Terror Act. Let me just address for a few minutes the last 2, what I consider to be dangerous and questionable provisions. The first is the provisions on warrantless arrest and prolonged detention without charges. This is quite unprecedented, and this is really a game changer. This, to us, is a violation, a blatant violation of the Constitution, because under the Constitution, it's very clear. Even in a state of martial law, or even when the privilege of the writ of habeas corpus has been suspended, the most that a person can be detained without charges is 3 days. Under the anti-terror law now, that has been extended to a maximum of 24 days, and that is without any court intervention. It is only the Anti-Terror Council that has the authority to allow that kind of prolonged detention without charges. The last is the power given to the ATC. Again, this is not found in the Human Security Act. First, to authorize prolonged detention, and second, to designate terrorist individuals or groups, because once you are designated by the ATC, that could lead to your being subjected to surveillance, your assets being frozen, you're being arrested without warrant, and you're being detained. And while it would have been all right, probably, if a court had this power, because at least in the court, you have a requirement of evidence, you have the requirement of due process, you have the requirement of notice and hearing and opportunity to be heard and to defend yourself. These safeguards are not found the power to designate that was given to the Anti-Terror Council. And that ends my short presentation. I'd like to thank you all for your attention, and I'm very willing to answer questions.
Thanks, Attorney Chel. I think we have a lot of questions actually here. Hang on a second. Let's just clear your screen. There you go. Yeah. I think we have a lot of questions here from the audience. I just want to say, I wanted to ask also, the Human Security Act, when it was passed, were there any protests around it?
Yes, there were protests. There were even petitions filed in the Supreme Court challenging the law. But the Supreme Court upheld the law and said that it didn't find any infirmities in the old Human Security Act.
And in your opinion, does the Human Security, I mean, you've shown us the differences between the two laws, but was it necessary really to replace the Human Security Act with this new anti-terror law? What conditions had changed in the country to warrant maybe an increase of terrorist activity, therefore necessitating a new law? I mean, do they have any real basis in fact for changing a perfectly adequate law from what I've seen?
Yeah, that's the same question that I had when I compared the two laws. And I've said this many times. The solution to if the government is really serious about stopping terrorism, which is a form of organized criminal activity, it's passing 100 new laws is not going to solve that problem. If government is really serious about addressing organized criminal activity, it must strengthen the justice system. There is no other solution except doing that. Increasing our conviction rate, which is really terribly low, making sure that justice goes faster in the country, that litigation doesn't take forever, filling up all the vacancies in our courts and in our prosecutors, because we have a terrible problem with vacancies. That will make us better in terms of addressing crime. But changing the law is really doesn't have any impact as far as making sure that there's accountability and that criminals get punished. And that's why I myself have questioned the need for repealing the law. In fact, the original bills that were filed recently, when they were filed, were not really to repeal the entire law. They were simply to amend the Human Security Act. But somewhere along the way, they were changed, and suddenly we found ourselves with an entirely new law.
But what are the chances now? There are 12 to date, or maybe more now, petitions before the Supreme Court questioning the constitutionality of the law.
There are about 20 petitions.
20 now, okay, it's grown. Now, I wanted to ask as well, how likely, I mean, you've spelled it out really clearly. So where it's constitutional, where it's unconstitutional, where there are flagrant human rights violations, and it's against the spirit of the Constitution as well, several provisions in the anti-terror law. Can we be confident that the Supreme Court will actually, point these out and, vote correctly on the matter, on the petitions before them?
Well, let's just say I am cautiously optimistic about the petitions filed. I say that for two reasons. First, because this case involves powers that belong to the courts that have been taken away from the courts and given to the Anti-Terror Council. And traditionally, the courts are very sensitive to issues when it comes to their own power. For example, the power to authorize detention, that has always been lodged with the court. And suddenly now it's been given to the Anti-Terror Council. The power to even the other powers mentioned in the anti-terror law, freezing of assets, surveillance, and so forth. While some of these have been given to the Anti-Money Laundering Council, at least as far as surveillance is concerned, that still requires court intervention. So I think when it comes to that, the court will be very careful in terms of studying the issues. The second, of course, has to do with speech. Because there's an unbroken line of jurisprudence going way back so many years, where the court has always said that when it comes to speech, that is at the top of the hierarchy of rights. Because if without with the freedom to speak the truth to power, we really have no democracy to speak of. And we're hoping that the court will realize that by prohibiting or penalizing speech through inciting to terrorism, that is going to have a tremendous chilling effect on not just on journalists, but on everyone, especially anyone who posts on social media. Because now people are going to think twice. Baka naman arestuhin ako, kasuhan ako ng terrorismo dahil meron lang akong pinost. And there's precedent for that because we've seen in this pandemic the NBI and the police arresting netizens simply for what they said on Facebook and other platforms.
And in fact, there was a general yesterday, the new AFP chief, right? He spoke about monitoring social media accounts as part of his remit in the under the anti-terrorism law. So that's quite chilling. That's actually terrifying, right?
Yes, yes.
Yeah. And he seemed to be proud about those powers, right? Okay, let's go to some of the questions. We have a lot of questions. I hope we can get to all of them. Would the president's interpretation of medical professionals asking for revolt with their statements under this act allow the police to apprehend the medical professionals sharing their views in mass media?
Well, let me put it this way. What I find very scary about the law is the power given to the Anti-Terror Council to designate people as terrorists and to authorize their detention. Let's take a hypothetical situation. Let's say that tomorrow the president comes out on television and says, the following people are terrorists, without giving any basis. He doesn't have to explain. Like when he came out with Narcolis before, he didn't say where he got the basis from or the evidence. What do you think the Anti-Terrorism Council will do? Once the president has made that announcement and given out those names, the Anti-Terror Council will probably have no choice but to do what he wants, which is to exercise their powers to go after these people as terrorists. And take note that under the law, the Anti-Terror Council is composed of all members of the executive department. It's headed by the executive secretary, who's like the alter ego of the president. The members are the Secretary of Justice, Secretary of Finance, the National Security Advisor, Secretary of Information and Communication Technology, the AMLA Director, and a few other cabinet ranking members. So all of them answer directly to the president. And once the president speaks, unless they want to be removed from their position, they will have no choice but to follow him. And that there lies the danger, because we've seen already instances where the president has spoken and without any evidence or basis. The first narco list that the president issued way back in 2016 included the name of a dead judge, a judge who had long been dead. And initially we were a bit amused by that, but then I realized, imagine the effect on living judges. They must have thought, kung yung patay na nga na judge ay naisama sa listahan na yan, o di napakadali na isama rin kami. So the chilling effect is not just on journalists, on ordinary people, but even in terms of the judiciary. And that applies as well to this crime of terrorism.
What about, you talked about freedom of speech. Now, what about joining rallies that are fighting for social justice? Would that fall under their very broad definition? Would anyone joining a rally against the administration or against current events, would that be terrorism?
Let's apply the definition. By calling on people to join a rally, you would probably be doing an act intended to cause serious bodily harm or to endanger people's lives because of the risk of COVID infection. If the rally resulted in the disruption of delivery of public services, that would be interfering with critical infrastructure. So you would meet the first component of the definition of terrorism. If the purpose is to create a message of fear, to seriously destabilize the government, to create a public emergency, and so forth, then that could easily fall under the crime of terrorism or inciting to terrorism.
Oh, okay, but related to that, we had the peaceful rally of the LGBTQ members of the LGBTQ community during Pride. It was part of their Pride Month celebrations, and they were arrested. I think you recall they were arrested. They were just taken off the streets, and then they were made to sleep, on the floor of the police station. Are they able, or the public as well, not just them, but anyone who feels that they've been wrongfully arrested or targeted as terrorists, what recourse do they have? Can they file for human rights violations?
Well, yes, they are not the only group that have been dispersed and arrested. You have the group of UP Cebu students who were protesting the anti-terror bill, who were also dispersed and arrested. You have some young people from Binyan, I think Laguna, or from Laguna, who were also arrested during a protest, and a number of other similar incidents. They would have recourse, but again, the problem is one of a climate of fear. Because in theory, you could file a case, a civil suit for damages, for instance. You could file criminal charges against the arresting officers of various offenses for interfering with your rights. But the main stumbling block that I have encountered as a human rights defender is that those who want to file are afraid also that what if I file and then pag-initan yung pamilya ko? What if I file and then bukas na bukas ay nasa listahan na ako? What if I file and I become the subject of an EJK? So that has been the biggest stumbling block. In theory, you could do it, but in practice, it's very difficult. Even I, as a lawyer, would have a hard time advising or suggesting to people that they file because of the risks attendant to that.
So in that case, what protection does the public have against this law?
That's the sad part about it. We are seeing our democracy shrinking in terms of our democratic space. We are seeing the accountability of public officers becoming less and less every single day. And to me, well, we have to push back. We have to continue speaking truth to power. We need to get more people aware of what is happening and to understand what we're losing in terms of our democracy. It's only then that this will stop, I think.
And who's here? I mean, who is here to check the government? I mean, let's say the Supreme Court says, okay, this law is fine. It becomes, it stands. Now, what about the Philippine? There's a question here: isn't the Philippine government guilty itself of sowing fear among the people? And if we are talking about critical infrastructure, disrupting telecommunications, information technology, food security, and supply in the guise of pandemic solutions, by the definition they've given themselves, isn't that like an act of terrorism against its own people?
Actually, that's why I call the law a law that is terrorizing the people rather than going after the real terrorists. And when you speak of state sponsored terrorism, that to me is the most dangerous type of terrorism, because when you have the vast resources of the government behind you and you're using those resources to sow fear, to destroy democratic institutions, to stop people from speaking up, to go after the media, to remove the separation of powers and checks and balances, then that's the worst form of governance that we could ever have.
But how do we counter this? That's the thing. I mean, if all our democratic institutions are being eroded one by one, what avenues do citizens have?
Well, if you look at the lessons of history, what we learned during martial law is that number one, we have to overcome our fear. Number two, we have to speak the truth to power, even if it may cause some risk to our own security. And number three, we have to get other people aroused as well. There's no substitute for fighting for our freedoms. Under this kind of situation, they will take it away from us unless we push back. And there's no choice. You cannot sit idly by and let things happen, because by doing so, you're actually surrendering your freedom to them.
True. But why do you think there was such a rush to pass this law during a pandemic? What was the
That's
rationale behind it?
I had the very same question. I think the timing in itself was very questionable, because we have so many other priorities that should be given attention by Congress. You have the issue of our economy, which is so badly hit by the pandemic. You have the issue of our public health. The health department, how is it doing in implementing the program? The PhilHealth now, again, we've seen what came out this morning. These are things that should be the highest priority, be given the highest priority by Congress, rather than an anti-terror law, or lately what they've been saying about reviving the death penalty.
Yeah, that just, and there's a bigger crisis involved, right? And they seem to be focusing on the the libel law was we saw during the pandemic the first application of the cybercrime law, and then now the anti-terror law, and now they want to bring back the death penalty. So everything is about sort of cutting our heads off one way or another, right? So I have a question here. Is an anti-terror law effective now despite the absence of its IRR, which is implementing rules and regulations, right?
Yes, the law, while the law does not require an IRR to be effective, the law does say that the implementing rules should be enacted in compliance with the requirements of the law. But even without the IRR, it is already in effect even now.
Okay. Did any foreign body, group, or country push the Philippine government to pass the Anti-Terror Act? Do we know what the agenda of the government is in passing the 8? Well, that's pretty clear. But yeah, I've heard people actually defending the act, saying that countries like Australia and Malaysia have far more stringent anti-terror acts, and we needed to upgrade ours. So I don't know. For me, I'm not sure that argument stands. But what would have been would there have been any external influences on creating that law?
Well, countries like Australia, even the United Kingdom, and other countries do provide for prolonged periods of detention, but that's because their constitution allows it. So whenever we speak of what we can put in our laws, of course, we all know that our laws have to be consistent with what our constitution provides. Now, as far as international pressure, what I can say is that when the Human Security Act was passed in 2007, there was a lot of pressure from other countries for us to have a terror law, because we didn't have any. So at that time, there was really a strong push, and that's why even if the legislators who were then in the Senate were really reluctant to do so, they did pass the Human Security Act. And that's one of the reasons why they put in a lot of safeguards, because they were afraid that it would be abused. But in this case, that we already had an existing law, I'm not aware of any strong lobbying or pressure from other countries for us to repeal that law and replace it with a much harsher one.
Okay. Then do the Supreme Court petitions questioning the constitutionality of this law present a prejudicial question that will warrant the suspension of the criminal proceedings or the enforcement of the law?
It wouldn't present a prejudicial question, but we are hoping that the court will issue a temporary restraining order. In most of the petitions, that prayer was included. And even if no TRO is issued, I think the government will think twice before they begin to implement it in terms of arresting people and prosecuting them. The biggest obstacle that we have in terms of the cases filed would be to get the court to allow a facial challenge, meaning that to question the law even without anyone being injured yet. So in our particular case, in the petition that I'm part of, we have the petitioners include journalists, educators, communicators, and legislators who have had that chilling effect, who have experienced that chilling effect, who know that this kind of law will make people think twice about their speech and will also cause them to self-censor themselves, which in a democracy is the last thing we want.
Mhm. So in terms of, there's a question here from Alvin Akayan. He'd like to know, would the Miranda rights not be practiced once a person is suspected of committing terrorism? And can social media, such as Facebook and Twitter, whenever someone speaks about the government, oh yeah, you've discussed this. But what about the Miranda rights? So when they arrest you, they can arrest you they can detain you without a warrant, but
Well, they would still have to read you your rights. The Miranda rights is simply a requirement that when arrested, the law enforcers must explain to you what your rights are. You have the right to remain silent, you have the right to counsel, and so forth. So that still applies even if you are arrested for a terrorist crime.
And what about now? Well, I'm just going through all the questions. There are lots of questions. What about shanty town or squatter dwellers who defend their shanties from unjust demolition orders? Like there was an incident recently with the PNP and somebody in Fort Bonifacio somewhere, right? They were trying to be, the PNP was trying to evict them from their homes. Now, in cases such as that, could they be accused of, considering the broad powers again, everyone, the PNP and the military have, can they be accused of terrorism?
You know what is scary about the law is the fact that there has been a lot of what they call red tagging in the last couple of months and years, where even legitimate non-governmental organizations that work a lot with the poor have been red tagged. Now, if the urban poor, for example, work with or receive help from these organizations, then they could be, because of by association, they might also be prosecuted. That's where the danger lies, and that applies across the board because there are so many NGOs that are working with the marginalized. They have everything from children's rights to urban poor to the rights of labor and environment and so forth. And across the board, many of them have already been tagged as communist, even if there doesn't appear to be any evidence at all that they are. So that's the danger as far as the poor are concerned, I think.
Now, would the Supreme Court have the authority to grant the ATC judicial powers to enforce acts which are supposedly exclusive to the courts?
Well, the court doesn't really grant any powers. It's Congress that does that. The court is there to determine whether the grant of Congress is consistent with the Constitution or not. And one of our arguments is that the Congress cannot give the ATC a power that essentially belongs to the courts. That's exclusively with the courts.
There's an excellent question here. How would intention be proven? Because now it's based on intent, right? So instead of actual acts. So what is the standard of proving intention? If you can be held without proof, right?
That's going to be the biggest question and the biggest challenge, both for the prosecution and the police, as well as for the defense counsels who will be defending people charged. But it's going to be a bigger challenge for the police and the prosecution because, like the question says, paano napapatunayan yan when that's a mental state? Of course, the law says that you can infer a person's mental state from the acts that he or she performs. So you would have to base it on the acts performed. But then that would be, of course, subject to debate. One side is going to say, because he did this or she did this, that means he had this intent in mind, while another person could say that, could disagree and say that's not that person's intent.
Okay, then we had, I believe it was Tito Soto who said something like, there's no need to fear martial law because we have the Anti-Terrorism Act. So was it? It was Tito Soto, I think, who said that, right?
Yes, and I think that was
Which is worse.
also an observation made by retired Justice Antonio Carpio, that with this law, you don't need martial law anymore.
And if the ATA, so if it's declared unconstitutional by the Supreme Court, will the Human Security Act be automatically reinstated, or that would have to go through another vote in Congress?
No, it would not. If the entire anti-terror law, the new one, is repealed or is declared unconstitutional, then it would not result in the Human Security Act being revived. The Congress would have to reenact it or come up with a new law. But the court, of course, would have several choices there. The court could declare some provisions only as unconstitutional rather than the entire law. It remains to be seen what will happen.
Okay, with the 22 petitions already at the Supreme Court, what would happen? What would the procedure be? Does the Supreme Court review every petition, or they view it all together? They take them all into consideration?
The court will probably consolidate them into one proceeding, so that you will have one big case where all the different petitions will be put into that one case. Then the court will probably ask the Solicitor General to comment on all the petitions. I understand the Solgen has already filed comments on the initial set of petitions that were filed. After that, the court has the option of either calling for an oral argument, which will probably be online if they do that, or for requiring the parties to submit memoranda, and then the court could decide the case already. So that's discretionary on the court.
And do you know what would have been behind the decision to extend the detention period for an unwarranted arrest from 3 days to 24?
What I've heard is that they need more time to build up the case. That's why they requested for a longer period of time. The other justification I heard is that the one you mentioned, that other countries have that long period of detention.
Yeah, but with much clearer conditions for terrorism, for the act of terrorism, right?
Yeah. You know, if I may add, if we're really serious about this, stopping terrorist activities, I think what we need is to build up the capabilities and the resources of our law enforcement. Because if you think about terrorism as an organized criminal activity, then there has to be an electronic trail and there has to be a money trail. Yeah, terrorists cannot do what they do unless they communicate and unless they have the funds to do those acts. And that is where government can identify them, track them, and apprehend them. So what I would like to see as far as the problem of terrorism is concerned is that kind of measure, giving them those resources, the capability, the know-how, the expertise, the equipment to do that.
And I've heard it said as well that they needed the anti-terror law because of the situation in Marawi to prevent events like the Marawi siege from happening again. But like you said, if there's no real, proper infrastructure in place to, let's say like that, to track the money, to, maybe more intelligence gathering and all that, how effective will this law be to prevent another Marawi from happening?
Exactly. And the situation in Marawi and what happened there was not because of the Human Security Act. It was really more of a question of what kind of intelligence and investigation was being done by the government, and how did they address the underlying issues. Because that we all know what the conflict is about and why it's been years and years that that hasn't been resolved.
There's a question here from one of the attendees. Yesterday or today, was it the Quezon City Task Force head Ludovica said that there would be a shoot to kill policy for anyone breaking quarantine. Again, we brought this up earlier, but can the police and the military be punished as well by this law, since they're the ones imposing a certain level of fear and destruction towards the people by saying things like that?
Well, the law is broad enough to cover state-sponsored terrorism because of the way it's written. It's so broadly defined that why not? I mean, since it's there anyway.
Yeah. Well, exactly. If it's there in the law, it should apply to everyone, right?
Yes.
But then, would you be harassed if you were to bring lay a charge against them? Would they come back at you and harass you as well?
Well, that's always a possibility. It's something that they have really made into an art form. That kind of fear. It began with the EJ case in the war on drugs. I spoke to so many families of victims who were outraged, who wanted justice, but um, were so afraid that if they filed cases, that their other members of the family would follow what happened to those who were killed, and that's really a big dilemma as far as we're all concerned. In fact, I hope that in the future we put in measures and the legal infrastructure that will prevent this from ever happening again. We have to have, for example, a very strong independent whistleblower system which protects witnesses, not just whistleblowers, but eyewitnesses to events, to ensure that they will not be subjected to any kind of reprisals. We need to have a really independent judiciary and a prosecution service that is committed to justice, not to politics. That will adhere to what is required by justice rather than what is what just kowtowing to what the president wants.
Okay, we have some students here are concerned with what's happening in the campuses today. There's a question here. As a campus journalist, if I wrote an opinion column criticizing the government, can the fair comment doctrine protect me from being tagged as terrorist?
It should, but whether the government, the prosecutors, and the police will share my opinion on that, I really wouldn't be able to say. One of the arguments that we have raised in our petition is that the law, the anti-terror law, by creating the crime of inciting to terrorism, is it's a blatant violation of our rights to freedom of speech and of expression, and that it is really meant to chill or to silence protected speech. So we were hoping that the court will listen to that argument, but we have yet to see what will happen.
Emilia Lastica asks, what can we tell our UP students who have been challenged at COVID checkpoints to declare their university organizations and fill up forms listing their affiliations, contact details, etc., so that they can protect themselves? Some of them comply because they are afraid, but that's not part of the DOH declaration.
No, it's not. And I think that would also be covered by the Data Privacy Act. So I would advise them to, as politely as possible, refuse to provide that information. And to ask the people at the checkpoint on what basis, by what authority are they being required to do that.
Now, is demanding to oust the president considered an act of terrorism, since it can fall under the idea of disrupting the fundamental political structure? And if those who spearhead the ATC answer to the president, wouldn't this mean that the president is now above the law?
Well, that's really two questions. The first question, I would answer that by saying that, yeah, the anti-terror, could you restate the question? That I just want to be sure I answer it the right way.
Second. Here.
I'll go to the second question first, the president being above the law. Well, I think it's pretty clear that in many ways the president is already above the law because he cannot be sued for any kind of crime or offense while he sits in Malacanang under the doctrine of presidential immunity, which the Supreme Court recently upheld. Any kind of case against him, even a habeas data case that I had filed on behalf of Senator Laila de Lima, the court said it's covered by presidential immunity and he cannot be sued. He can be sued after when he steps down, but not while he is sitting as incumbent president. And in that sense, that really allows him to do what he wishes and without any form of accountability. Of course, in theory, he could be impeached, but the problem is, of course, he enjoys such a great majority in Congress that is a very remote possibility.
And
Yeah.
no, I mean, I'm just saying that's also an incentive for him to hold on to power to avoid prosecution after he leaves the office, right?
Well, if history
Yes.
teaches us anything, it teaches us that. Yeah. I'm sorry, could you ask me again the first part?
No, well, I think we covered it really. It's just maybe we need to repeat it about if demanding to oust the president. You know, there's a hashtag I've seen trending that says oust Duterte. So if they're able to trace who posted that thing, you know, would that could fall under this law, right? You could be picked up or arrested under the ATA.
Well, let's say if you apply the definition, it could fall under inciting to terrorism. I mean, my own personal opinion is that is still protected speech. But if, in the eyes of the government, if they were to read that law the way they would want to read it and to apply the definition as worded, then it could be interpreted as saying that you are seriously destabilizing the government, sowing widespread fear, and so forth, and say that then, and to conclude that that's covered by the law. However, I do want to say that as much as possible, we need to really push the envelope. We need to assert our speech in terms of what is legitimate criticism that's protected by the Constitution. Because the minute we surrender that, then in a sense, we are already allowing them to limit our basic freedoms.
But John Christian has a question here. Would you say that the Congress didn't meticulously deliberate the law before passing it, knowing its unconstitutionality, or was there evident pressure from the executive or personal interests behind the swift passing of the law? That's kind of a tricky question.
There was a certification issued by the president that certified the bill as urgent, which triggered actually Congress to speed up the deliberations. That's why it took so quickly that the law was passed. And that's why they even dispensed with a bicameral conference, because the lower house simply adopted the version of the Senate that did away with the requirement of having a bicam. Usually it's when there are laws like this, it's often in the bicam that some questionable provisions could get ironed out, but that didn't happen here. Now, in terms of pressure, well, I think we've already seen how powerful the president is in this administration insofar as Congress is concerned, and how easily Congress kowtows to what he wants.
Now, corollary to this, and we were talking about the oust Duterte hashtag. What about if you were to post hashtag let Lenny lead? Would you also be considered, could you be tagged as being a terrorist for that sort of hashtag?
I think that would already be bordering on the absurd if you were to be charged with terrorism for that, because that's very clearly protected speech, legitimate expression of opinion. We shouldn't be afraid of posting anything like that.
And this anti-terror council, who the president nominates them? I mean, who's going to compose it, and when will it be announced?
So the law provides for the members and the head of the Anti-Terror Council. So the law says that it's headed by the executive secretary and the members are the National Security Advisor, the Secretaries of Justice, Information and Communication Technology, Finance, the AMLA Director. I don't recall exactly the others, but they're all members of the Executive Department.
Do you believe that the executive branch became too powerful, having its influence on the legislative and judicial bodies? Well,
Yes, you know, we've seen our government is based on the principle of separation of powers and checks and balances. That's how it's supposed to work. Unfortunately, under this administration, those checks and balances have been pretty much neutralized. In terms of Congress, of course, we know that they do whatever the president wants. In terms of the judiciary, we have seen how the Chief Justice, the highest official of the judiciary, was removed without impeachment by means of a co-warrant proceeding, which is really not how the framers of the Constitution intended that position to be. We have seen as well indirect attacks on the independence of the judiciary by the inclusion of the names of judges in narco lists. Because that really has had a chilling effect on other judges, because their thinking is if this judge could be put on the list, then my name could easily get into that list also if I do something that the palace doesn't like. And that has affected, I think, the quality of this administration of justice in the country.
I'm just going through the questions now. Okay, there's one in Tagalog. Attorney Chel, thank you po sa pagpapaliwanag now that naliliwanag na ako. Paano po nasasabi ng iba na for prevention daw po ito? What is he trying to prevent, and is it warranted? I guess is the question. Am I right?
Sa tingin ko, hindi naman ito yung tamang solusyon pagdating sa problema ng terorismo. Sabi ko kanina, ang dapat palakasin natin yung law enforcement capabilities, yung kanilang know-how, resources at equipment. Hindi bagong batas ang solusyon sa problema ng terorismo. Kaya we can conclude, I think, that the law could easily be used for other purposes, especially for purposes other than legal, meaning to go after critics of the administration and perceive the members of the opposition. Just like, in fact, if I can go back to address that argument na sinasabi kasi nila na dapat matakot ka lang dyan sa batas na yan kung terorista ka. Well, let me tell you my own experience. After the elections, all of us who ran for the Senate in the opposition, except for one, and then also the Vice President, Leni Robredo, among others, were charged with inciting to sedition. If you recall yung Bikoy video. Now, wala kaming kinalaman doon at wala rin kaming kinalaman sa sedition. And yet, we had to suffer the agony of being charged and going to the Department of Justice to answer the criminal charges filed against us. And by the same token, if you follow what happened to us, then now that we have the crime of inciting to terrorism, it's not only suspected terrorists who could be charged with that crime. Any single person, any one of us, could be charged with inciting to terrorism, depending only on how the police interpret what we say. And we've seen in the past how the police have interpreted the posts of some netizens to say that that is inciting to sedition and arrested them without warrant, just like we were charged with the same crime. So the danger of the law is to me very real and very concrete.
We have a lot of students here, as you know, joining us today. So another student is asking, can the police and military use the provisions of this law to enter universities? For example, in the case of police personnel arresting student activists within the vicinity of UP, campus as opposed to the Department of National Defense Accord?
Well, for universities like UP that have existing agreements with the police, then even with this new law, the law enforcement is still bound by those agreements and should honor them. For other universities, however, especially if the owners of the universities agree, then there would be no real obstacle to them, entering the campus. That's probably where the danger lies.
And now, one of the justifications for this act was what was happening in Marawi. So what would the implication of this law be for our more Muslim brothers and sisters?
Well, I think that they would be one among the more vulnerable as far as being targets of prosecution and arrest and detention are concerned when it comes to this law. In fact, even I understand even when the Human Security Act was the prevailing law, most of those who had been arrested and were in jail for terrorist-related crimes were Muslims. So we can expect that they will also be vulnerable to this new law.
Now, there's some people who believe that our rights could still be safeguarded by providing good IRR. Do you really think that a sound IRR could help solve the ambiguities of the ATA?
The IRR can only implement what's in the law. They cannot change the provisions of the law. They cannot add to what the Congress has put in there. They can only implement it. So if the problem is the law itself, no IRR would be able to solve it. For example, the provision in the law that allows 24-day prolonged detention without charges. Maski ano pang gawin nila sa IRR, that's not going to change what's in the law. So there might be a few things that could be, maybe some more safeguards that could be put in the IRR, but I can't conceive of anything that will really save it from the challenges we see as far as the Constitution is concerned.
With China's National Security Act, which was just passed as well, and for Hong Kong, would it also kind of be a kind sort of encouragement as well for this administration to just to sort of justifies the ATA somehow? I mean, if China's doing it and then they swooped in quickly to enforce it.
In one sense, that is true, in the sense that the law provides that any acts committed even outside the Philippines are covered by the anti-terror law. You notice the definition I showed earlier in the slides. It says within or outside the Philippines. And I think their rationale for that is what is known in the international legal community as universal jurisdiction. But I personally disagree with that notion, because the concept of universal jurisdiction was created for purposes of human rights accountability. It was not intended for this kind of terrorist activities. But that is one of the justifications I think that China has been using, and as well some of our legislators.
The National Security Act in Hong Kong has also impacted academic freedom. So there's talk now of changing the curriculum in Hong Kong and more in line with what China wants. What about our academic freedoms here? Would they be affected by the ATA?
Well, if you go by what happened to the UP students, remember after they were arrested, one of the USECs branded them as terrorists. So that in itself, although she later removed her post or her tweet, that she did make that tweet. I'm not sure if it's a tweet or a post. Now, if that's any indication, then it is a sign that this could be used to quell protest, especially among the students, and that of course is of much concern.
But this law cannot be applied retroactively.
No, it can't.
Okay.
Prospective lang siya from the time it took effect on July 22.
Do you have any advice for the youth who are very vocal about their political views and opinions?
Well, I think that we should not stop expressing our opinion. I think we should not stop in terms of speaking truth to power. That is, to me, the greatest power that we have as citizens. At the same time, if you want to be sure that, well, not to be sure, but at least to minimize the possibility of being harassed or arrested or detained, then I've said this a lot in a lot of my talks. You just have to make sure that, number one, what you say is not libel or cyber libel. So you don't want to personally attack the honor or reputation of another person. Second, you don't want to incite people to take up arms or to do any acts of violence against the government or against other people, because that is also a criminal act and it's not something that would be protected speech. And third, you don't want to violate the right to privacy of other people. Yun lang naman ang limitations natin as far as speech is concerned. As long as what we say is with regard to a matter of public concern, as long as it's legitimate criticism, as long as it's an expression of our opinion on a matter of public interest, then that should be considered as protected speech.
Okay. We have here, I think, a government employee who doesn't support this law. Would his dissent or her dissent constitute the disruption of essential services if we were to participate in a rally, such as the teachers and public hospital nurses initiating work stoppage, to raise valid concerns like wages or working conditions? Well, those are valid reasons to rally.
Well, the Supreme Court has said that a government employee does not lose his or her right to freedom of speech just because they are part of the government. But having said that, the Supreme Court has also said that government employees don't have the right to strike, which I disagree with, but that's in the law, that's in the decisions of the court. So if there's no problem insofar as expressing your opinion is concerned, I believe, but if it is in leaving your job during office hours or engaging in stoppage of work, then you could get into trouble for that, because your employers would probably say that that would be dereliction of duty and violating the limits on the peaceful concerted activities for government workers. But in terms of, for example, engaging in a protest during weekends or during non-office hours, there should be no impediments to that.
But journalists are seriously impacted by this law as well, right? Because they're probably with the way the administration has been targeting members of the press, and and obviously other media institutions, then they're also targets of this law, right? Implied targets of this law.
Definitely, and that's one of the reasons why a number of them have joined as petitioners in the cases filed in the Supreme Court.
Okay, I think we can take one more question. Okay, this is an interesting one. If you're arguing against DDS, a Duterte supporter, what's the best response once they begin to bring up the severity of terrorist activity in Mindanao, obviously as a justification for this law?
Well, I think the best argument is to say that what will stop terrorism is the certainty that the terrorists will be punished. It's not the severity of the punishment. So that we could have 1 million death penalties laws, for example, but if the powerful can easily escape prosecution and punishment, then those laws have no value at all in terms of stopping things that we don't like to happen. So whether you're pro-administration or anti-administration, we all want a stop to organized crime. Mm-hmm. And the solution to that is not a harsh law, but making sure that people who commit these crimes will be punished, that they'll be identified, that they'll be arrested, and that they'll go to jail. And that is where we've been lacking for so long. And to me, I could never understand, and up to now I don't understand why our government, our political leaders have not made this a part of the national agenda when it is such an obvious problem, systemic problem we have. We don't have a working justice system. We have a conviction rate of less than about 30%, which means that 7 out of 10 people prosecuted go away scot-free. We have a serious problem with delay, where cases can take anywhere from 10 to 20, even up to 30 years before they're decided. And that translates into a justice system where the people have totally lost confidence and believe that there's a double standard of justice in the country. And to a large extent, that is a very correct observation. So if we're really serious, if government is serious about stopping terrorism and other organized crime, the solution is really strengthening the justice system. It's not passing these laws.
Well, this was a platform you ran on, right? Last year when you ran for the Senate. Yeah. Now, when you talk about organized crime, with that 15 billion from PhilHealth, be part of it.
That's our problem. There's been so many exposés, but if you were to track how many of these exposés have resulted in actual convictions and in people actually going to jail, diyan tayo nagkukulang. And that to me is why the biggest obstacle to our development as a country lies in our justice system. And it's deliberate. Our politicians don't want to talk about it because they don't want to have a strengthened justice system, because they're afraid of accountability and they're afraid of empowerment. And those are the two key aspects of a working justice system.
So are we doomed as a nation? I mean, how, we've gone from one administration to another. And I was listening to a talk last week in New York with Sheila Coronel and Liloy Claudio. And they were saying that, Filipinos tend to elect very different leaders after one term, then they kind of go for a little bit of the polar opposite of the other one, which is certainly the case in the last two, this administration and the administration prior. But if that's never been a priority for any administration, how do we demand that? I mean, we're demanding better traffic conditions and better public transport. It still hasn't happened. What else can we as citizens do for to improve the justice system in this country?
I don't think we're doomed. I have never lost hope, even during the darkest days of martial law. I think that there has always been this really strong need inside us to have justice, and that really is what impels so many of us, especially young people, who are really looking to change the country. And that's why I always say that if we're just talking about our generation, I've probably given up hope. But if I talk about and I think about the younger generations and those to come, we need to do something for them. And that's really what I'm dedicating my life to, is doing some things that will result in a change for the future.
Okay, I think we're about ready to close. Can I thank you so much, Attorney Chel, for joining us today. Thank you, everyone. We've had a big crowd today. Before we close, I'd just like to ask Attorney Chel, by the way, this is going to be on YouTube. It's live right now, but another recording will appear on YouTube in a couple of days if you'd like. I'm going to ask, some of you have asked for the presentation. I'll check with Attorney Chel if he's willing to share it, and we'll let you know. Although you can catch the presentation as well on YouTube once it's up. So before we close, can I ask you for any last words? Any message to a terrorized populace?
Well, I'd like to thank Manila House for the opportunity to share my views on this thing, this law. But at the same time, I'd just like to harp on that point that we can't give up. We can't stop hoping. And if we want change in this country, then we need to take it upon ourselves, at whatever risk, to do it and to insist that we have accountability to insist that we strengthen our justice system and to insist that the government address the needs of the people and put the people's interests on top of its own. It sounds simple. I know it's a bit. We will say that it's difficult, but to me, if you look at the lessons of our history, we can never underestimate the power of the Filipino spirit, and we can never underestimate the power, our power as a people. Thank you.
Thank you. Thank you, everyone. Thank you so much. Thank you, Attorney Chel, for giving us your time today. That was very, very informative. And thank you for giving us a little bit of hope as well. Just to remind everyone, among our members, we have 3 other webinars coming up this month. We hope you can join us. Just check the newsletter for the schedule, or Facebook or Instagram. Next week, and we have nothing next week. August 17, we have a workshop with a Singapore-based photographer who will teach you how to maximize your mobile phone to take the best pictures, which I suppose we'd all like to do now that we're under lockdown. And then on the 18th at 10 a.m., we have a webinar about the Buffalo Soldiers, who were the Black American soldiers that fought alongside the Philippine revolutionaries during the Philippine-American War. In fact, they defected to the Philippine side, and some of them settled here and raised families. Danny Glover, the actor, is a producer of the film clip we're going to show on that day. And so there's been a five-year project now doing a documentary about the Buffalo Soldiers and their relationship with the Filipinos. And then we have a talk on August 25 about writers, Ateneo University Press. Writers, 3 internationally acclaimed writers who are Filipino, and they will talk to us about writing during the pandemic and how it's affected their work. So thank you once again for joining all of us, and we'll see you next time. On behalf of Manila House, we're so happy that you joined us today. Thank you, Attorney Chel. Bye.